Hello, and thank you for joining us today. My name's Khara Boender, and I'm State Policy Director at the Computer and Communications Industry Association. As you're probably aware, state lawmakers have been increasingly active in the tech policy arena, introducing and considering a flurry of proposals centered on content moderation, privacy, online safety, competition, and to a growing extent, artificial intelligence. Most state legislatures have been in recess since June, but in the peak of legislative sessions, typically January through June, we saw a variety of proposals across the 50 states led by Republican and Democratic lawmakers alike. There is no sign that this trend will slow down, and as we just wrapped up Thanksgiving celebrations, there is a constant reminder that January is just right around the corner, and with that, state lawmakers are poised to reconvene. So, what did we see this past year, and what can we expect to see in 2024? To dive into this topic, I'm joined by several experts who work closely on state tech policy issues. Joining us today are Ted Bolema. Ted Bolema is both an economist and an attorney. He served for over 8 years with the as an attorney with the Antitrust Division and also as a policy advisor with the U.S. Department of Energy. Ted also was a partner in Anderson Economic Group, where he served as an expert witness in several antitrust and trade regulation cases. He retired last December as executive director of the Institute for the Study of Economic Growth at Wichita State University, and he is currently an antitrust and competition fellow with the Innovators Network Foundation and a senior fellow with the Mackinac Center for Public Policy in Michigan. Shoshana Weissmann manages R Street's social media, email marketing, and other digital assets. She also works on occupational licensing reform, social media regulatory policy, Section 230, and other issues, and has written for various publications, including the Wall Street Journal and USA Today. Shoshana most recently managed digital communications for Opportunity Lives, a group that highlighted positive stories and policy solutions. Before that, she managed social media and wrote for the Weekly Standard. Earlier in her career, she managed digital communications for the America Rising PAC, where her strategy was highlighted in a piece that appeared in the New York Times. She is on the board of the Conservation Coalition and a member of the Federalist Society's Regulatory Transparency Project's state and local and emerging technology working groups. Andrew Kingman is president of Mariner Strategies, LLC. Among other clients, he represents the State Privacy and Security Coalition, which works on data privacy and cybersecurity issues in all 50 states. As a public policy advocate with experience in compliance, he brings a unique and substantive perspective to discussions on how best to increase consumer privacy protections while maintaining operational workability and cybersecurity protections for businesses. He is a nationally recognized thought leader in the field, and in 2020, he was one of 25 attorneys named to Massachusetts Lawyers Weekly Up and Coming Lawyers list. So thank you again for taking the time to share your perspective today. And I think I want to start with setting the stage. Can each of you describe what we're seeing across the states? Andy, let's start with you. States have been especially busy discussing privacy. What are we seeing?
Hey, thanks, Khara. I think we're seeing two things. One, we're seeing the widespread adoption of comprehensive privacy laws, going from one state in 2018 to four states between 21 and 22, and then last year having an additional seven states passing comprehensive privacy laws. So on one hand, we're seeing widespread adoption of what we would describe as a relatively uniform framework across state lines. And then on the other hand, we're seeing a number of sectoral privacy bills like consumer health data, biometrics, and children's privacy, where legislators are trying to bite off one particular aspect of privacy and regulate just that. And we've seen that be less successful, but we anticipate significant activity on both of those fronts.
Awesome. Thank you for giving us a lay of the land on that front. Switching gears a little bit, Shoshana, we've seen several variations of proposals concerning content moderation. They tend to, come from different sides of the aisle, but they're both sides of the aisle are trying to address content moderation in their own way. Can you describe what we're seeing there?
For sure. So, for a while, I think that you saw a lot of Section 230, even at the state level, which is kind of funky, aimed legislation. And it kind of, some of it was, went somewhere in like Florida and Texas. And there were bills across the country. But the big thing now really is age verification powerhouse of social media. It's for pornography as well, but I'll be focusing on the ones really focused on social media today. Um, and 4 states so far have enacted it: Texas, Arkansas, um, Louisiana, and Utah was the first to do it on the social media side, at least. And basically, it's you're basically seeing all these states want parental consent for people to, to be able to log in online if they're under 18. There have been a lot of other proposals, though. When I actually just checked this morning to get an updated statistic, there have been over 1,000 bills. I think 1,300 bills containing the word social media. And for age verification, it's fewer. It's in the hundreds, but that's a lot of bills. A lot of them didn't go anywhere. I've heard in private conversations that there are legislators who understand the issues with these, which is why in certain states that these proposals didn't advance. But there's a lot of energy around this, both at the federal and state level. And I've actually been quite surprised how many state proposals have passed and how much energy there's been around it. So there's some real legislative successes for that side there. But as I'll talk about, there's a lot of institutional and functional issues with them.
Thank you. Gosh, that updated statistic of over 1,000 proposals containing the word social media, that's definitely remarkable and a bit hard to fathom. So again, switching gears a little bit, Ted, can you talk about how competition and antitrust have been featuring heavily? I think we're seeing this in two different capacities, both at the legislative level across several states, and then, of course, in terms of enforcement. What has been keeping states busy in that area?
Well, yes, state antitrust enforcement was a pretty quiet area until just recently. I felt like there weren't that many of us paying attention to it. But yes, certainly have gotten much more activity just recently in the two areas that you mentioned. So a lot of the cases are being brought by states. Well, states can bring cases under their own antitrust laws and also in the federal courts on behalf of the citizens of their states in the federal system. So I think one of the things we've been seeing in the cases being brought is kind of a shifting away from the consumer welfare standard that the federal courts still follow, although we'll see how much pushback or how successful the federal antitrust agencies are in pushing back against it in the cases they have going, and shifting more toward more of a big is bad sort of focus, particularly targeting the big tech companies. So a lot of this activity has been more in the, I'm overgeneralizing here, but it's been generally more in the blue states than in the red states, kind of consistent with the enforcement policies of the Biden administration, but also definitely some interest by red states, particularly concerned about censorship and other sort of conduct that they're worried about, maybe biased against conservatives, and so that's led to some interest in more red states in also getting involved.
Awesome. Yeah, thank you for providing that overview. And staying in the competition lane for the moment, you alluded to the fact that this has largely been a topic amongst some blue states. So, states that come to mind immediately are New York and California, of course, who tend to be usually leading the pack in what other states follow in terms of policy proposals. I think what we've seen is that this has tended to be a longer term effort, with the legislation that's been proposed in New York, running across several different sessions because it has not advanced, or in California where we see the Law Revision Commission embarking on a study which has been ongoing for some time now and it's continuing into next year. Whereas we tend to see states move more nimbly than Congress when it comes to passing this type of legislation. What do we think is driving the, slower move on the competition and antitrust front?
Well, it's a complicated area, so it's one that it's easy to say we need to crack down on these big tech companies, and then then when legislatures start hearing about all the implications of it, it is a more complicated issue than it first appears. But yeah, the two states you mentioned are the two that have been kind of at the forefront for quite a while. So New York was almost the co-lead with the Justice Department in the Microsoft case 20 some years ago. And California, the state Supreme Court has already ruled that the California courts don't necessarily have to follow the consumer welfare standard. So those are a couple kind of obvious ones right now. I think that's a lot of the motivation by California not joining in the case against Amazon, is that if they're under their state law, they don't necessarily have to be bound by the consumer welfare standard.
And so why do we think, other states that haven't traditionally been part of this conversation, like Minnesota and Maine, why do we think they're starting to enter the fray? It sounds like New Jersey and Michigan are also going to tap into this topic as well.
Mm-hmm. Yes, yeah, there are several out there. Well, I think there are, kind of activist groups out there that have been pushing for more active antitrust enforcement for a long time, and a lot of them are the ones I believe are proposing the legislation. So, they say we can be more like Europe and other countries that are moving in this direction, and it's working so well for the technology industry in Europe. So let's bring this to America through the States, I guess.
Fair enough. We're going to pause on the competition conversation for the moment and move on to privacy and content moderation. But I think as we come to the conclusion of this later, we'll have a chance for all three of these areas to overlap in a substantive way. So Shoshana and Andy, I know that Shoshana, you specifically mentioned talking about the online safety proposals. And I think especially from the age verification front, this has implications for both privacy and content moderation and how that impacts users. What are some of the issues that we can describe if we, had a room full of lawmakers? What would we want to say to them about why those proposals might be misguided?
Oh man, where do I start? I started writing about this, and I'm long-winded, I'll admit, but I ended up at 20,000 words of issues, and it's not. There's more. So there's actually a lot that lawmakers have been receptive to when I've spoken to them, to their credit, even if they didn't always follow along and agree with me in the end. They kind of understood these issues. So the first is a lot of these laws try to get around age verification by saying, oh, well, you don't have to verify age. It's just if you already know they're an underage user. Cool. So then you're like super opened up to lawsuits. So of course you're going to verify age if it's, if you reasonably know someone is a minor. So in order to verify age, I mean, it's not a perfect system. There's definitely better tools than there used to be, but it's not great. It's government ID. It's biometrics. Yeah, want that spread all over the internet. Security issues. I'm trying to think, a lot of it's like face scans, stuff like that. But people try to make the argument on the other side a lot of times that, well, it doesn't verify identity. It's just about age. But you kind of have to verify identity in order to verify age, especially for minors. Let's say you have a 16-year-old child, and you want to allow them to use social media. So you have to prove that you're the parent of this child. So all identity. This is way beyond age now. And then the platform has to make sure that you're the parent and they're the child, and that your ages are what you say, your names, all of that is correct. Some of these have included home addresses. So as you can tell, this is creating a massive cyber risk. A lot of the bills say, sure, delete the information after you verify age. Okay, but for compliance, how else are they going to prove it? I mean, it's a massive incentive to keep this information. And so that's just on the functional side, some of the issues that basically you can't protect privacy and cybersecurity and have these laws at the same time. The next is constitutional issues. There is 30 years of precedent really getting in there about, hey, you cannot do this. This, literally what we're talking about now. I won't get into all of it, but basically we have a First Amendment right to anonymity, well established. Children have First Amendment rights, well established. And when they tried credit cards for sort of age verification, for I think actually pornography more in the late 90s, early 2000s, the court said, look, this creates First Amendment anonymity rights. There's parental filters. You should definitely encourage people to use that. But this creates so many First Amendment problems. Another actually really interesting one is with VPNs. So let's say Utah, for example. Utah's law actually expressly states that you can't get around. It basically talks about VPNs. It doesn't say VPN, but it basically means like, hey, someone can't get around this by trying to be like anonymous online and making it seem like they're outside of your state. Okay, so then you have to verify age for all VPN users. that would violate California law, which says you can't treat VPN traffic differently. Fantastic, just impossible compliance. This is super great. Um, I know I'm being silly about this, but honestly, it's really impossible to comply with. And furthermore, you can't always detect VPN traffic. And if you create incentive to use VPNs in this way, people are going to, and the market's going to evolve. You're going to have more VPN use, and a higher percentage of traffic will be not, you won't be able to tell that it's VPN. I spoke to actually VPN providers and VPN blockers, and they basically said, yeah, this is going to create some really dark incentives for people to use less secure methods, and stuff like that. And plus, outside of all that, IP addresses aren't super reliable because a lot of these talk about people who are in Utah or residents of the state, stuff like that. But people who live on the border of states, that's not going to do well. IPs and cell towers aren't always super accurate. Plus, IP addresses show a lot about you and also further violate your privacy. There's so many issues here. I talk about it much longer than I am now, but basically, this isn't functionally possible. And when you enact these laws, you create adverse incentives for people to use less secure stuff. The final point I'll make is that a lot of people don't use VPNs to be anonymous. They try to just avoid being tracked. Like, I don't mind people knowing I'm Shoshana. I just don't want them to know all the stuff I'm doing online. But this creates incentives to also not let them know I'm Shoshana, not let them know I'm based in DC, not let them know all that kind of information. Which, I mean, it's a whole different kind of use of VPNs. It's similar to the other use, but if people are going to be using VPNs in that way, it's going to make the whole process a lot harder and just everything less possible than it already is. And for what it's worth, some lawmakers really do seem to understand these issues. Not all of them are going to change their minds because of it, but they really do understand that these are issues. They just think that there's some magic way around it.
Thank you for walking through a lot of those technical and feasibility issues there. I think that a lot of what we're seeing is that there's almost a catch-22. You are trying to solve this problem of providing more safety, but you're introducing a host of other problems, not to mention the fact that when you're doing this state-by-state approach to regulation, you, as you mentioned, might end up actually violating other states' laws. So you end up in this situation where you need to pick and choose which ones you're going to be in compliance with, and I guess willingly able to not comply with other state laws. So it makes it really difficult. Andy, did you want to add to anything on this front?
Yeah, I think so this is the crossover that we're seeing, right, is that on bills like the AADC or bills that are trying to incorporate some elements of children's privacy that are beyond what are in comprehensive laws right now. Yeah, I think the only thing I'd add to Shoshana's point is that on the advocacy front, for those of you, looked like there were a fair amount of trade association folks involved. For those of you who are speaking to policymakers about this, this isn't a case where, business is on one side and civil society is on another. When it comes to age verification, there are a lot of civil society groups who are very concerned about age verification, the negative consequences of age gating, et cetera. I don't know why this is generating thumbs up reactions, but there are any number of civil society groups. I'd encourage folks. The Center for Democracy and Technology sent a letter to Congress around the Kids Online Safety Act, COSA, dealing with many of the same issues. And if you look at the signatories on that, it's all civil society groups. So my only point being, this isn't an area when we're talking to legislators where we have to be, sort of defensive or, well, you don't understand the business implications. This is an issue that lots of folks are concerned about. And it is complex, and there aren't simple answers to, to protect kids, to figure out who's a child and who's not when you're talking about who's behind a computer screen.
Makes sense. Anybody else want to comment on what has been shared thus far? Otherwise, I might want to dive a little bit deeper into what we're seeing on the kids' safety front.
Yeah, I'll just add super quick that Andy's point's really great, especially because, I mean, lawmakers are just like, oh, screw these companies, they hate us, and all. You have that kind of energy from lawmakers. And I do try to point out the compliance issues, but I try to not make it about business. Like, not, oh, these poor businesses, but like, hey, if you want them to be able to do this, this isn't going to work. And I think, like, Andy's point's really important. You have to bring it back to, like, about the protection and about the regular people and less about the businesses, even though lawmakers should care if their laws are impossible to comply with.
Absolutely. Yeah, you would hope that they would care about the whole swath of impacts that policy has. I think, diving into specifically the overlap with privacy. So I think what we've seen across the states is a lot of states that don't even have a comprehensive data privacy law are kind of trying to leapfrog and skip that step and move straight to online protections only for children. What types of ways could lawmakers avoid going at that approach? I'm thinking of Virginia, which includes protections as part of its comprehensive data privacy law that include protections for kids. What would we say to lawmakers in terms of kind of pushing them down that road to consider comprehensive data privacy and framing it in that way?
Yeah, I think comprehensive privacy has the advantage of when we're talking about kind of the Virginia Connecticut framework, right? This is something that has been really vetted, for 4 years out in Washington State, and then through again 11 states that have gone through this. So think of all the committee hearings, all of this stakeholder input. I maybe this is a sad commentary on how I spend my free time, but I went through and added up all of the votes on comprehensive privacy in the 11 states that have adopted it thus far. And it's 1,341 votes for these bills and 30 votes against them. And that's again, across the 22 chambers and 11 states that have adopted this. So, it's a model that we can fairly say is overwhelmingly bipartisan. Again, it's been supported by consumer advocates in various states. I think in the overlap of like, why do comprehensive, we hear sometimes from legislators that, well, we don't, comprehensive is complicated. We'll just bite off, one piece of this and, attack children's privacy or, biometrics. And what we try to sort of say is, look, like there's a model that everybody is, nobody thinks is perfect, but everybody's reasonably okay with. And, let's go down that route rather than try to, pass something that's almost invariably going to end up in litigation being enjoined. Having said that, I think you can credibly make an argument that the comprehensive bills, allow children either, depending on what age they are, through their parents or individually to, delete their information, to access their information, to correct information. We've had different ages for targeted advertising being an opt-in instead of an opt-out. So, it has been 13 to 15 in California, and in a couple of other states. Delaware last year moved that up to under 18, so that individuals under 18 would have to opt into the sale of their information and targeted advertising instead of opting out. Businesses are required to do data protection assessments around processing children's data. So, there are any number of safeguards here, and again, that have just been vetted, that have been worked on by industry, by consumer advocates to try to balance the various competing interests. And so, that's really where we'd advocate taking a look if we're going to try to do something around children right now, because I just think there's no clear answer. We've had kind of the blue state version with the AADC, and we've had the red state version with the states that Shoshana mentioned. We haven't had a court that's found either of those approaches constitutional yet.
Yeah, it definitely seems to be a problem all around, whereas the comprehensive privacy route seems to be a solid one. I love all the stats that you guys are offering today because that's really impressive to hear the number of votes for versus those opposed to those bills. Um, and I think, that touches upon another thing, prior to last year, most of the states that had comprehensive data privacy laws were, so to say, blue states, whereas last year the bulk of the states that passed laws are red states. But to your point, they're largely following the same model. So I think that there is a lot of cohesiveness to the approach there. Um, Before moving on to another hot topic, just want to make sure, Ted and Shoshana, if there's other items that you want to touch on before we move away from the online safety topic specifically.
Yeah, I'll just jump in to say that one other thing I want to mention is just that when you have the separation of children and adults and age verification goes far against privacy. So I think while a lot of lawmakers think they're actually protecting kids, they're very much not, and they're making it a lot worse. And I think one other piece of that too is, when you create all these barriers for kids to learn how to use social media, parents can decide on their own and create filters, and I have no issue with that. But kids need to learn how to use these tools properly, and it's very easy for kids and adults to be scammed. I mean, bank fraud is up really high right now. I have friends and my father too. They all keep getting bank accounts made in their name, and they actually are pretty good with stuff. But you have to learn how to recognize that, how to monitor for that, how to use social media responsibly. I've been on social media since I was a kid. And it's why I'm here today. I learned how to network with elected officials on social media, on Facebook as a teenager. I don't want to rob kids of that chance, but more than that, you can learn how to use stuff productively, or you can be thrown into it when you're 18 and have criminal liability and a higher standard of that. So I think it's very unwise from a privacy and cybersecurity perspective not to put all those barriers, and also to teach kids and parents, hey, you should totally give up your most personal information every time you want to post online. It really takes privacy in the opposite direction.
Yeah, it kind of creates this perverse incentive where you're teaching your kids, don't talk to strangers, but you're also saying, please offer all your information up online. But you can't really explain away the contradiction there, right? Um, since I know online safety was a huge topic in 2023, and I know it will continue to be one leading into next year, but I think we all are well aware that AI, artificial intelligence, automated decision making is also factoring heavily on lawmakers' minds. Um, Given the amount of interest that we've seen from lawmakers to quote unquote do something on AI, how do you all see the desire to regulate AI tying into legislation affecting, consumer data privacy, content moderation, but also how could approaches to regulation impact the competitive landscape as well? So I want to hear from all of you on this one. And let's start with Ted.
Okay. Well, this is not my strong area, but yes, I am aware of states looking at AI legislation. And my impression up to this point is it tends to be focused on a lot of issues that aren't really so much AI issues, like how it affects political campaigns and political campaign finance, or how it affects privacy or things like that. So it doesn't seem like the discussions I've heard have been too targeted on how do we encourage this great new technology that has the potential to be incredibly transformative versus whatever legitimate concerns there might be about it. So my concern is not being viewed through the right prism yet.
Hopefully. Yeah, I think, what I'm seeing, I'm happy to have you all agree or disagree, but, I think everybody wants to do something around AI, right? But there is sort of some red state, blue state divides that you can kind of tease out where, blue states are very worried about disparate impact, various types of discrimination or discriminatory impact that AI might have. Red states, I think, are more concerned around like algorithmic prioritization, right? And like making sure conservative speech on online platforms isn't suppressed. I think in all of those cases, many states have pretty robust anti-discrimination laws, right? And so what we try to ask legislators to do is please look at those first, because many of those regulate the outcomes of discrimination and are agnostic on, whether the discrimination is intentional or unintentional, or whether it's, automated or due to human error, or human intent. And so, we're trying to ask lawmakers, please be thoughtful. Let's go slow. The other thing that's more just my opinion here, we don't even really know what AI is yet, right? I mean, a couple of years ago, it was, using AI for job interviews, for types of screening, was where the legislation was focused. Now we're seeing it, focused on large language models. But I mean, my sense is that large language models will comprise a fraction of the utility of AI moving forward. And so I'm not sure that what the utility of regulating those versus trying to think more holistically will be. I think the way that we see it interacting with privacy is that it's very privacy adjacent. So the structure of these bills are often very similar to the structure of the comprehensive privacy bills, where data impact assessments are kind of a critical component of them. There may be some consumer rights associated with the use of automated decision making, right? Whether that's access or opt out, and then that in turn, raises issues of disclosure, transparency, protection of proprietary information, security and anti-fraud concerns, et cetera, et cetera. So some of those issues are the same. Now, some of them are very different, and I suspect Shoshana can jump in on the differences. But I think we are seeing some of the same issues. I think the other key point that's similar is that a lot of the state legislators who got comprehensive privacy passed, or are known for being leaders in the comprehensive field, have moved on to trying to get AI passed, and so are piggybacking off of their prior work and their ability to, be considered experts in their caucus or in their state on technology issues. So, I think that's the other similarity. I'll jump in and let others.
Yeah, I love that. I think I'll just add to that. It really is the piggybacking of issues. Since 2016 or so, there's just been this anger at social media, and there's definitely a lot of AI legislation that is a long continuum of that. It went from all our areas, and others have been a part of this, just anger, often at constitutionally protected speech, just people mad that there's bias or appearance of bias or something like that, even though that's all constitutionally protected. So there is a real just kind of stuff that I don't have as much respect for there. There are some more productive efforts with AI, though, I'll say, mostly at the federal level. I know this is focused on states, but I was actually kind of interested to see at the federal level when I was doing research on what's been out there, that there's a bunch of bills that want to just fund AI, which is funny to me because it's like, hey, this is doing fine. I'm not really sure why you need to throw money at a thing that's starting to thrive right now, but sure, I'm cool with that, whatever. Also, a lot of good energy to learn how to use AI in government that I think is fantastic. I think, it's good for government to be pro-tech and adopting tools. And then you also see some of that energy I was talking about at first, like Hawley and Blumenthal, just like, hey, let's remove Section 230 for AI, just because I hate Section 230. And you're seeing the same kind of stuff in the states. There have been a lot of laws around discrimination. That's been at the federal level too, legislative proposals. But like Andy was saying, at our street, my colleague Adam Thayer talks a lot about, hey, let's not duplicate existing law. Laws already cover this. It's like there's people who are saying, oh, well, if you use AI to create libel, you're going to be liable. Yeah, you're already liable for libel. You don't need to duplicate that. Existing law covers, I think, a lot of stuff. I agree with Andy too that I think privacy is, I think, one of the most genuinely more interesting angles in cybersecurity issues. I really sympathize there, and I think there's a little bit more to do, and I think there is energy around that. But there's also just a ton of energy around layering existing law, which I don't really care for because it doesn't really do anything And it's a waste of kind of everyone's time. I think for the most part, though, efforts here are a little bit more constitutional, which is something. But you're definitely seeing a lot of continuation of existing energy, and then just this a little bit more positive new energy of, oh, maybe we can use this for something, which is a little encouraging from our government, which has not been super tech optimist over the past couple of years.
Yeah. The last thing that strikes me as useful in terms of AI, where regulation could be helpful, and I'm not an IP lawyer, but I think my sense is that in the IP space, right, current copyright and trademark and patent laws probably aren't set up to deal with large language model type inputs and outputs, and where you're getting that information from and how you're generating that information. And that would be a useful place for AI legislation to focus on if you wanted to try to update existing laws, because I think my sense is that those are areas that probably aren't modern enough to grapple with these type of issues.
Awesome. Thank you for sharing all of that. I think we've alluded to a lot of what I'm about to bring up next, and that's how enforcement actions and how what's been playing out in the courts in terms of litigation might influence what we see next year. So, of course, with the CCIA and net choice cases in both Texas and Florida, I think that in this past year, while we did see one state pass a bill that was akin to the Florida and Texas laws in Arizona, which ultimately got vetoed by the governor, several other states considered such proposals, but they did not make it across the finish line. So I'm curious to hear all of your perspectives on, how the cases in Arkansas are going to play, and California, both on the age verification law and AADC, those preliminary injunctions, how that might shape the landscape with regard to online safety. And then Ted, would love to hear from you about how you think the various state enforcement actions in the antitrust realm might shape policymakers' discussions in 2024. So why don't we start with Ted, since antitrust is a little more divorced from content moderation and privacy.
Okay. Sure. Well, yeah, there have been a lot of these cases going on. So the one in the news the most lately is the Google case, that trial in D.C., which is led by the Department of Justice, but I know like about a dozen states joined in that one. So that's on the Google search engine being the default search engine, among other issues there. But there's also a case led by Texas floating around on the monopolization of the advertising market. There's the Apple Store case that's still out there. A couple cases were brought against Facebook, now Meta, but Facebook at the time that were dismissed. And then a couple of the big ones were again this year were against Amazon, the first one for its negative options so some states joined in that one too, even though these are both led by the Federal Trade Commission. That's the supposedly the use of dark patterns. The FCC used that term. Sounds kind of ominous to trick people into either signing up for Amazon or renewing their membership, make it too hard for them to terminate their membership. I kind of analyzed that one clinically at first and just looked at what the economics of it was, but I've had the chance to talk to several different audiences about it. And I'm always, I guess I'm getting used to it now, but I was surprised the first couple of times by what a reaction I got on that one. And so usually, why does anybody need to trick me into signing up for Amazon, or why would I want to cancel? But anyway, the FTC and some states are going forward with that one, and then the big one is the more general antitrust case. So California has a case against Amazon for focus mostly on its price parity policy, and claiming that it's because of its size and some of the things that it can do, that it has an unfair advantage over competitors, and somehow that's leading to higher prices for consumers. It kind of feels like on both the California case and the Justice Department case that these are kind of giving lip services to the impact on consumers, and it's really kind of like I said at the beginning, kind of a big is bad focus, and the likely beneficiaries are going to be more the competitors of Amazon, like Walmart and Walmart.com or Target.com, or else some of the bigger retailers that do business on Amazon, but don't necessarily need all the great services that come with Amazon. So, with all the, obviously these big companies can watch out for themselves in the cases that they're bringing, but my big concern with all of them is that. It's kind of like what Shoshana's been emphasizing here, that there's all these unintended consequences for everybody else who has to interact with these companies and how it's going to be affected. That is Amazon going to still be able to deliver or do its 1 or 2 days deliveries if they have to separate their distribution from some of their other operations, or how does these cases affect app developers, or other sort of businesses that are more entrepreneurial and doing business with these companies and kind of using them to jumpstart, or maybe using them as their exit strategy at some point that they're hoping maybe to sell at some point. And what incentive will they have going forward to keep innovating? So I think the real negative are concerned about the real negative impact there. But I think with all these, it does kind of feed into this big is bad mentality, and I think that is also leading to the legislation that we've seen introduced in at least 4 states already, and likely we'll see several more next year. Do you want me to talk about those, or should we hold on that one for later?
No, yeah, please describe which ones.
Okay,
yeah.
Great. So yeah, there's if you look at the legislation, there are 4 provisions that pop up. 2 of them I think are maybe a little less troubling, and 2 of them I'm very concerned about. So one is prohibiting monopolization. I'll take the 2 I'm less concerned about first. Prohibiting monopsonization, looking upstream. That might be implied already from the state antitrust laws. The federal courts have always said that it is implied from the federal antitrust laws, but that's looking does the downstream party have the market power? I think the focus there by the more activist interests that are pushing for these laws is looking at labor markets, and labor being an input. So are employers monopsonizing a labor market? And that goes to the second provision also, which is a ban or a limit on labor non-compete agreements. You see popped in there too. So that's a trend that's been going on. California has banned them already. The Federal Trade Commission is pushing to ban labor non-compete agreements. So I've signed several of them in my career, and they've never really been a problem for me. And I kind of see the economics of why they do make sense to have. But so anyway, those are the 2 I'm probably less concerned about. The 2 big ones, which are actually in all 4 of the state legislations legislative proposals we've seen, are first a shift to a European type of abuse of dominance standard. So replace the consumer welfare standard with abuse of dominance. Well, I think that requires a lot of, gets away from the consumer welfare standard for one thing, which I think is certainly well worth preserving and having that to discipline our antitrust enforcement. But second, I think it's beyond the ability of governments to really manage an abuse of dominance standard. It requires a lot of judgment as to how the market should work. But that's Europe adopted that standard a few years ago, and there's a proposal to do that. And it fits with the big is bad sort of agenda. And also one that I see in these statutes is a prohibition against companies raising pro-competitive defenses for their actions. Well, that's at the core of every non-per se antitrust case that we look at. We look at the harms and then the pro-competitive benefits and try to balance them. And so those provisions are saying, let's not look at one side of the ledger when we evaluate these cases. So I just really don't know how that's going to be operational when states, if a state passes that and then gets its first case. I just don't know how they're going to deal with that, other than if the government says that conduct is anti-competitive, is that pretty much the end of the case? I imagine that's probably the intent, but of some of the authors of these statutes. But I'm worried about how that would play out.
Yeah, I think that's a really great point. And as you were saying that, I too share that concern, because it seems like it's just creating a wall to being able to talk about, essentially defending what your business model is and why you are helpfully contributing to the competitive field. So I guess it will remain to be seen what happens next year. But I think, it's not just the tech industry that's going to be impacted by those types of proposals. It could be far reaching and have a lot of adverse impacts for both, businesses and consumers alike. I'm sure that we could talk about how the pending litigation for the online safety and content moderation proposals are going to play out, and how they'll impact how lawmakers go forward next year. But what are you all anticipating will occur?
I'll go. So I don't know why you guys are so concerned about a government trying to outlaw due process. That seems totally reasonable. I just can't get enough of it. I mean, like, they're going after sandwiches, and a friend.
I was just about to say, we're worried about that and sandwiches. Those are the things.
Yeah.
Yes.
Yeah, like a friend, Patrick Hedger, had a really good point that is now something I'm going to use at every opportunity. If a child can make the thing, I don't think you have the right to bring an antitrust case against it. Like sandwiches, like clay figurines. I just had to say that because, like, come on. And on a related note, I really don't think lawmakers care if what they're doing is constitutional. And like, I actually understand the thinking that, like, their court failures have led to less certain kinds of legislation. I actually think it's just a difference in I think it's just moved from one place to another. If they can't do one thing, they'll keep at it. They'll keep trying to do it. But if they find something else to hook onto, then they'll just move on to that. For one, I adore Spencer Cox, the governor of Utah. I think very highly of him. I hate what he is doing, and he knows it. But he's a smart guy. I tend to really trust his judgment on a lot of things, but it's been strange to me how he thinks what he's doing is constitutional, especially because he is such a smart guy. I'm not sure if he's just saying it or what, but regardless, he thinks what he's doing is constitutional. And I hear lawmakers say it all the time. Even Senator Schatz has said something to the effect with the age verification laws that that platforms don't have an unfettered right to access your children, even though that's, to me, a very backward view of how free speech works and access to speech as well. But the point is, I just don't think lawmakers care what they're doing is constitutional. I don't think they care how much money they waste from the state. Multiple different friends have come to me with the idea of maybe there's a way to penalize lawmakers when they do something that's unconstitutional, and like blatantly so. And I love the energy, but I just don't think there's a way. But all that just gets to the point that they really, really, really don't care. So I think enough court losses could beat them back down. I think that's kind of what you saw like 30 years ago. But I think it would take a lot of court losses. It would take Supreme Court losses, because they're not going to believe it until it comes from the Supreme Court, and probably multiple times over. But even conservatives who I've spoken to, who I know really care about the Constitution, or say they do, and who will go off on it all the time and on constitutional rights, they just really both kind of don't seem to get it here, and also don't seem to care, and don't seem to care about what the court says. And as a big Supreme Court nerd, I have some views that I don't think the Supreme Court would agree with, which is fine. But this is one where this isn't just me going off. This is like decades of precedent from all different sides, from Scalia, from Thomas, from Kennedy. Like, this is not disputable. Like, this isn't like, oh man, maybe we'll win at court. I would be really, really shocked if any of these laws ended up holding up when they go to court. So this is just a long way of saying there's a lot of reasons, but I don't think lawmakers care if it's constitutional. And I think sometimes they just believe that it is for some reason. And I don't think court losses are going to stop them, at least not for a long, long time. But it's not great. It's not great, but I'm not sure if it's worse than going after sandwich monopoly. So
my hope, is that maybe this is my institutionally optimistic side talking here, but that at some point, like I always say, listen, I'm not a neutral broker, but I am an honest broker, right? That at some point our concerns that we express to lawmakers about the consequences of their actions will maybe they will start to realize, like, we're not being, Pollyannish about it. We're not lying about the unintended consequences. On the privacy side, we're going to see the first bill with a private right of action go into effect in 2024 with the Washington State Consumer Health Data Act. And I've got colleagues who have, published on that bill, who have said they've already started getting calls from personal injury attorneys in Washington State going, "Hey, I heard about this bill. Maybe we can do something with that." And so, I think my hope is that we'll be able to say, "Look, we told you this was going to happen. Now this is happening." Hopefully that buys us some confidence. I think the other thing, to Shoshana's point about lawmakers not caring, I would say there are lawmakers who are thoughtful and who are willing to work with industry. And I think, my feeling is, first of all, those are the lawmakers who have a record of actually getting things across the finish line, right? Is listening to us and saying, "Look, I'm not going to give you everything you want, but we'll give you a fair hearing. We'll take your concerns into effect. Tell us what the absolute, red lines are, et cetera, et cetera." And I think, as advocates and policy wonks and folks who are talking to those legislators, we need to make sure that they feel the love when they do get stuff done, that is done, in concert with us, and that, we're taking time at panels or at conferences to call them out. Not because I don't think any of them can be described as, industry shills or anything like that, but folks who, came to industry with a problem that they wanted to solve and asked for input and then genuinely worked with us. I think, we owe it to them to, try to make sure that they know we appreciate that and, try to reward that type of collaboration.
I think that's a great point, because I think too often it is framed in this almost like adversarial realm, or, there are some advocates who will say, well, if industry likes it, then it's bad and it's not good enough, more broadly. And I think that's just fundamentally a misguided way to be looking at it, because ultimately we all have to work together if we're going to be trying to effectively and meaningfully achieve these goals. So I think that's a really important point. I know we're coming up on time, so I want to give everybody their last word. And I think we'll end this on, what are you keeping the closest eye on for next year, and why? And again, if you had ability for a PSA directly to lawmakers in that state, what would you want them to know? Anybody can go first. Feel free to jump in.
I think California is the easy answer with what the CPPA is doing, and that's a whole other webinar about regulatory overreach that we don't have time to get into today. But I think beyond the CPPA in California, for me, it's Maine, and that state's come up a couple times. But we're seeing this dynamic where states that had been divided for a while, when they switch, where you get both houses and the governor of one party, it's like when you're at college and the parents are gone for the weekend, and it's like, no rules, let's go, whatever we want to do, right? And I think making sure our message this session on comprehensive privacy in particular is, look, you don't have to reinvent the wheel. We have something that works. If there's a particular issue you want to address within this, we're happy to try to, workshop something that can work, within the context of what the rest of the states are doing. We've got 20% of the country covered by this framework at this point. We've got almost 40% covered by a comprehensive framework. And so, we don't need to reinvent the wheel. Let's not try a brand new model that's going to isolate your state.
Yes, always eyes on California, and interesting to see Maine enter the fray. That's not usually one of the top of my list, but certainly we'll be keeping close track of it next year. Shoshana and Ted?
Well, I worry a little about my new state of Michigan. I'm a Michigan native and moved back this year, but with the Democrat legislature and governor, they've shown a tendency to push bills through really fast. So I do worry that a privacy bill or an antitrust bill or something else could land on the agenda and be passed very quickly before we have much of a chance to weigh in on it.
Yeah, I think that's the risk with all of the trifectas that are amongst the states. With the compressed legislative schedules and the trifectas across state government, it makes it really easy for lawmakers to move something swiftly without necessarily getting all stakeholder input. So always a risk there.
Yeah, so I'm worried about all the states that I never expected would do stuff just jumped at age verification this year. States where I thought people knew a little bit better for doing it. What I've been trying to do is see which state lawmakers I know remember how freedom works and are willing to talk about it. And I've actually had some luck. There's a couple of legislators I'm friends with across the country who are like, yeah, what the heck? Like, I don't like social media, but this is not how the government's role is supposed to work, which has been encouraging. But I don't really have any particular state. I mean, California is definitely one where I'm paying attention, and Utah, because I need Spencer Cox not to break my heart again. But every state where I know people, I just kind of remind them, hey, if you want to talk through how policy works, how stuff might work here, just let me know. I'm really trying to be very visible on the issue because I think it's very important. It's not great. Even if the stuff gets struck down, I don't think it's good to waste taxpayer money. And it's also bad political energy to keep going at unconstitutional things. And one thing I just always try to leave them with is all of the different issues, depending on what I know they're interested in. I try to make different points. Like, I know that there, unfortunately, are some lawmakers concerned with cybersecurity who are really into these bills. I try to remind them, hey, if you're concerned about this, you should also be concerned about this. It's really hard because there's still this anti-industry energy. And sure, I have problems with like different tech companies. Like, I think we all don't like companies sometimes, we all do sometimes, but that shouldn't be an animating factor for just going nuts on unconstitutional legislation or not fixing actual problems. And it's actually really frustrating. I try to celebrate lawmakers when they do good stuff, even ones where it's out of my area, but I think it's a cool idea. I try to highlight them, but it's actually sometimes hard here because when you do that, it can make them look worse because it's like, oh, she's on the wrong side of things and she supports you and she likes this idea. And especially from industry, it can look really bad, it's sad. It shouldn't work like that. Like, good ideas should be able to be celebrated. It just doesn't always work that way. But one ray of hope I'll leave you with is, not a political thing, but just a policy angle. When Nikki Haley was talking about ending anonymity online, there was huge, people were just flipping out, including Ron DeSantis, who is not super great in that area, and also other elected officials who have effectively tried to end anonymity online. And people pointed it out, but also piggybacking on that energy, I think, is good, looking for more opportunities to point that out, to point, hey, this thing you hate, this thing you seem to like is also that thing you hate. There's a moment here, and I think we should be capitalizing on it. I wrote about it, but look for more of those moments, and I think it'll really be around. But that was a shining light for the last week for me. I'm like, guys kind of get it.
Thank you for helping me to end this on a positive note, and really appreciate that. And of course, I appreciate everybody who's on this call for all of the efforts in trying to work on that narrative and working together with lawmakers to, bring everyone together and work towards a goal that actually achieves those goals, not introducing another host of issues. I also like to try to keep everybody on time, and I know that we are now, in fact, past when we were supposed to end. So I want to thank everybody who joined us online today, and also extend a huge thank you to you, Ted, Andy, and Shoshana. I really appreciate you taking the time today to share your perspective and your expertise, and hopefully we continue working together moving forward.
All right. Well, thank you, Khara.
Thanks so much, everybody. Really appreciate it. Thanks, Khara.
Thank you.